What is a tort? Well, essentially it's a civil wrong. There is some disagreement as to whether we're talking about the law of torts or the law of tort, singular, because they are very diverse. You have negligence, nuisance, trespass, defamation. All these things are torts. So what binds them together? Well, they protect different rights. They protect your personal rights, your right to be protected from being physically injured as a result of someone's carelessness. They protect your economic rights, the right not to lose your income because of someone's carelessness. And they can protect your property rights. Torts such as nuisance and trespass protect property rights. And some torts overlap with other areas of law. So, for example, if you drive your car too fast, you knock someone over, you're committing both a criminal act and a tort, the tort of negligence. So what is the difference between the two? Well, criminal acts are regarded as offences against everybody, whereas because tort is a civil action, that would be regarded as an offence against the individual as well. So what's the difference between the law of tort and the law of contract? Well, the similarity is they're both common law systems, they're both judge-made systems of law. The difference between them is that we freely enter into our contractual obligations. We freely decide whether to buy a newspaper or any other type of contract. So they're what are called consensual obligations. Whereas tort, although they're also common law obligations, they're obligations imposed on us. They're non-consensual obligations. So the law is telling us not to behave negligently, not to commit nuisance, not to defame people, and so on. So if we now move on to the aims and aims of tort compensation. Well, what is the law of tort trying to do? Well, it's got a number of objectives. You could say it's to appease people, to buy off victims and to buy off their sense of wrongdoing if they've suffered as a result of someone's carelessness, say. To create justice, there's two elements to this. There's a form of retribution, that if you commit wrong, that you're held to account for your wrong and you're individually accountable for the wrongs you've committed, and as well as to compensate someone for the wrong that you've done them. There's also a deterrence aim, to deter people from engaging in harmful behaviour, to associate a cost to that harmful behaviour and therefore deter them from committing it. But the main objective of the law of tort is to compensate people as a result of other people's wrongdoing. Now, if we make a start on the law of negligence, the modern law of negligence starts from 1932 with the case of Donoghue and Stevenson. Before that, there was no law of negligence as such. There were just sort of what were called duty situations. In a certain type of situation, you were liable, and in another type of situation, you were liable. In 1932, we had the case of Donoghue and Stevenson. And now the facts of this case were that the plaintiff's friend had bought her a bottle of ginger beer, and when she'd finished drinking this ginger beer, she alleged that she found the remains of a decomposed snail at the bottom of the ginger beer bottle, and she had gastroenteritis as a result. She couldn't sue the person who supplied her with the ginger beer because she was not in a contractual relationship with them. So she sued the manufacturer. And it laid down Lord Atkin's famous neighbour principle, that you owe a duty to whoever is your neighbour. And your neighbour in law is someone who's closely and directly affected by your acts. And the significance of the Donoghue and Stevenson case was that it created a law of negligence. Instead of having disparate duty situations, we now had some underpinning principle that linked these different situations together. Now, by itself, the neighbour principle was too vague to be applied in every type of situation, so it was in need of further definition. Now, a major breakthrough in terms of development of duties of care came in 1970 with the case of Anns and London Borough of Merton. And in the Anns case, they said there was a two-stage test for deciding whether or not to impose a duty of care. And the first stage, they said, was there a relationship of proximity between the parties? And if your answer to that was yes, then you moved on to the second stage of the test, which was there a policy reason for withholding the duty of care. The ANS test started to fall into disfavour. It was meant to be a general principle of general application, so you applied it to every type of situation, this was novel, a novel approach, and it could have expanded the law of negligence, and when it was applied, it did expand the law of negligence and created duties of care where none had existed before. So it could have dramatically expanded the law of negligence. Eventually, it was repealed. The ANS case was overruled in the case of Murphy and Brentwood, and currently what is used is a so-called three-stage test, which was laid down in the case of Caparo and Dickman. Now, the three-stage test asks yourself, is there reasonable foreseeability of harm? Is there proximity between the parties? And is it fair, just and reasonable to impose a duty of care? And it didn't separate out the policy considerations from the proximity considerations in the way that the ANS test had done. And for this reason, it was much more preferred by judges. It sort of rolled up the questions of proximity, foreseeability, and fair, just, and reasonableness, and didn't specifically address the issue of proximity.